I'm Manabu Matsunak from Nagoya University. Next, we have a session by Professor Andrew Lin from National Taiwan University on transforming Taiwan's director disqualification into the optimal model. And from a comparative perspective, this paper is very interesting, especially for Japanese, because we share the very fundamental basic regulation, but Taiwan grew and transformed the disqualification system completely different from Japan. So as a Japanese, I am like watching the hypothetical future, the future we didn't take. So first I thought, when I saw the title of this paper, I thought this paper is about closed corporation, but it was not. It's about listed corporation. So it's very interesting in many ways. So please, Professor Lin.
Thank you for the introduction. Good afternoon. I would like to use this opportunity to thank Stan, SMU, and so for sponsoring such a great event. Okay, so from the earlier sessions, I want to mention 3 persons: Ellen, Jennifer, and Christopher. From their comments, presentations, and then talking about whether this paper has anything to do with the main theme of this year's conference, sustainability. So I'm talking about corporate sustainability, corporate culture, climate change. So Jennifer mentioned sustainable development of a company. We need to have a good corporate governance. So how do we measure? So one of the factors mentioned by Virginia yesterday is the first one is to lower the agency cost. So we all know agency problems. Okay, so we impose directors' duties in the Company Act. So Ellen says, why don't we just remove the unfit directors? Why do we make them accountable through them? Which one is easier? Both are difficult. Okay, so I'm going to use the topic director disqualification regime. So I'm not going to talk about accountability of directors. I'm not going to talk about, but it's related. Okay, so first of all, cool. I have to move to the next slide. Okay. So it's all included in this slide. Okay, so why not just to remove the directors? It's difficult. So the topic, director disqualification, by definition in this article, my definition is that for any means that can remove unfit directors or supervisors from its position, any means are all included, considered to be part of the disqualification regime. So I take the broad definition. Okay, so remove directors. This morning we mentioned about you can use shareholders meeting, but it's quite rare and it's difficult. So, and Christopher mentioned about the corporate structure, shareholding structure in Taiwan, and I also talked with one of the directors in a listed company. I say you should probably can suggest a good friend, so you can suggest this to the chairperson to discuss how to protect the company. He said, well, this is a good question. I will discuss this with the chairperson, but he decides. So the corporate culture in Taiwan is the majority companies, even though there's a board, is democratic. The law also says that you have to say something in the board meeting to avoid your liability. You have to challenge and do something. But basically, the business culture is that you will respect the decision of the chairperson. Not 100%, but I think majority people will just respect. Unless you did something wrong, then I will try to say something. Otherwise, for most decisions, that will be leave to the chairperson to decide. Okay. So difficult to remove a director is because several unique features. The first one is that we have a juridical person director, or so-called legal person directors. So a company can be elected as a director. Then he can appoint a natural person to be the representative to serve as the director function in the investee companies. Okay? Juridical shareholder, institutional shareholders can also appoint several representatives to be elected individually. So according to the Company Act, Taiwan's Company Act, all of these representatives can be replaced by the institutional investors anytime for any reason. So that is the problem, that even though you are going to remove that natural person from the spot, but the juridical person can replace the person with the other one. Okay, so that would be one of the proposal at the end of this article, talking about whether juridical person itself should also be removed. So once you are removed, you cannot appoint any representative in the future for a period of time, something like that. Okay. Shareholders meeting, difficult. Okay. So we have shareholder proposal in the year of 2022. Checking upon all the shareholder proposals of listed companies, only 2 companies, you can see only 2 companies with a shareholder proposal to remove directors. One case, 7 proposal from one company trying to remove 7 directors. Okay, and these are all included in the shareholders meeting. However, it did not pass general meeting because of the voting. The voting, it didn't pass. The other case is that 5 proposals to remove directors, including independent directors. However, the proposal was not included in the agenda of shareholders meeting without providing explanations. So that is some problem with the shareholder proposal regime in Taiwan. Okay, so my research in this article, first of all, I will introduce the disqualification regime that we currently have. So basically, I will talk about, we can move to the next one. Okay, so the first one is negative qualification. So you probably all heard of negative qualification. In order to be a director, you need to meet certain qualifications. And negative qualification is that you cannot have all of these circumstances. So for example, you cannot committed organized crime. You cannot have committed an offense that is breach of trust, something like that. Okay, so that are included in the negative qualifications. So the general negative qualification can be found in the Company Act, Article 30. So this provision was introduced in 1966, and it was modified twice, but with minor changes regarding the circumstances of the negative qualification. So this is the first one. And the second one is, so negative qualification is that if you have any of the circumstances, you cannot be a management. You cannot be a manager, you cannot be a director, you cannot be a supervisor. So, but if you are already a responsible person, you are automatically disqualified. That is the legal effect imposed by the Company Act. And the second one is judicial removal of directors, that you are suing the directors to discharge the company, but it should be decided by the court. Okay? So traditionally, under the Company Act 200, the courts usually are very reluctant to intervene into the corporate affair. Okay, so our rule is that there must be a shareholders meeting. Fail to remove the directors, then you can come to the court. When you come to the court, you have to prove, you have to show that this case has been brought to the shareholders meeting for the reasons that I'm going to borrow Virginia's materiality concept. So you have materially damaged the company, or you have, materially violate the law, regulation, or articles of incorporation. Okay, so materiality is important. So 3% shareholding is the threshold to bring the litigation. So very rare, very rare. So then we invent a new regime in the Securities Investor Protection Act in 2009. Okay, so the judicial removal of directors has two versions. One is Company Act, one is Investor Protection Act. Investor Protection Act applied to listed companies, public traded companies. Okay. And so then you will see the next one is ancillary disqualification legal effect collateral to discharge judgment. So I use this term. I couldn't find any other term, but I use this term. It's because of the SFIPA, Investor Protection Act, was modified in 2020 to introduce the disqualification legal effect. So once the director is removed, the court makes the judgment to remove the directors. The director will be not only be removed from the current office, but also for the next 3 years, you cannot serve as a directors or supervisors. Okay, we currently don't have the disqualification by trial. We don't have the disqualification undertaking as being adopted in the United Kingdom or other jurisdictions. Okay, so I point out the first thing is that there's a changes of the scope of the negative qualification. So the reason I mention this is that it can be changed. So in the future reform, we can seriously consider to modify the scope of negative qualifications. Okay. And the judicial removal of directors for the Company Act provision, Article 200, as I just mentioned, difficult. But for the first version, 2009, when the SFIPA can bring a discharge litigation against the director or supervisors of listed companies, it doesn't work that well. I will show you why. Okay, so and then in 2020, we introduced the disqualification effect. So what I would like to say here is that 2009, we just think of to remove the director from the spot. 2020, we are thinking not only for protection of the shareholders, but stakeholders. So if a responsible person is doing something wrong, it will harm not only shareholders, but investors, but stakeholders as well. Okay, but does it work perfectly, of course not. That is why I'm saying there should be a reform. So there hasn't been a reform. I hope there should be a reform in the future. Okay, so from 2009 to the end of March 2024, there are a total of 100 cases brought by the Securities and Futures Investor Protection Center. Okay, it's a nonprofit organization, bring class actions, and also they bring a representative derivative suit. And also here we are talking about the discharge litigation. So for the pending cases, there are a total of 37 pending cases. 31 is applying new law, and only 6 applying old law are still pending. So new law, old law is that new law has disqualification effect for 3 years. Okay, and this slide includes the 63 closed cases. So among these 63 closed cases, only 8 cases applying the new law, but 7 cases, the Investor Protection Center won the litigation successfully, thank you, discharged the directors. But there was one case in the pink highlight. This is a Supreme Court judge. So I also want to introduce now, beginning from 2020, we have a commercial court. Okay, so all the litigations brought by Investor Protection Center is now exclusive jurisdiction of the commercial court. So after commercial court, you will appeal to the Supreme Court. So it be more efficient. But for this case, we have one case that talking about some issues related to whether you can sue a director if he resigned. If he resigned during the litigation or before the litigation. Because right now the disqualification effect is attached to the discharge litigation. So challenges by the defendant says, I'm not a director anymore. You cannot remove me from the spot. Okay? So we have cases that during litigation, defendant resigned, and the court says we can continue litigation. There's still, litigation interest because there's a 3-year disqualification legal effect. But if the director resigned before the litigation, now is the issue. So currently we have 4 Supreme Court cases that have now submitted to the Grand Court. We have a Grand Court. The function is to consolidate the opinion of the different panel of the Supreme Courts. So it's currently in the Grand Court. Okay, and from the rest cases, which is probably not relevant right now because that was in applying the old law. But by applying the old law, the issue is that if you remove a director, you think that you have met the goal. No, that's wrong. Because even though you can remove the person, he can be re-elected. So you remove him, he can be re-elected next month. So he come back to the board. So that is problem. So we are talking about we need to have a disqualification kind of thinking to, just to exclude the unfit person away from the managerial position or in the board. Okay, so issues I have just talked about just now, so I will not repeat. I'll just mention for the rest of the issues because I have only 2 to 3 minutes left. Okay, so the issues related to judicial removal of directors connecting to the ancillary disqualification effect after August 1st. You can imagine that there are several types of, under the current regime. So if a director engage in misconduct in another company, can you sue him? Because he is not conducting the misconduct in this company. Can you sue a director for the misconduct occurred in the previous term? How about 10 years ago, 20 years ago? Can you sue him based on that? That would be another issue. So we also have one provision which is very, I think it's also causing the controversy, is that there's a provision talking about in the course of performing director's function. So what does it mean in the course? Then I look at the UK company director disqualification code. It mentioned about in connection with promotion and so on. So that would be more broader than in the course. So these are all the issues I raised. And so the comparative studies, I don't have time to talk about that, but I need to do more, detailed research on that. So currently we are, just look at the beautiful clothes from UK and US. Some of the concept, some of the idea can be borrowed, but we, of course, we need to know whether it is suitable in Taiwan's business culture. Okay, so proposed reform mainly focus on unfit person. I'm not talking about incompetence, but unfit person. But what is the scope of unfit person? Okay, so do we need to have a disqualification regime applied to all company, or only to listed companies? So currently, I would say that company law is applied to all companies, but for the SFIPA applied to listed companies. So this will be a issue that need to be discussed in the future. Okay, I need 30 seconds, okay? So once a person is disqualified, whether he can be removed from the spot, but we are going to prevent this person from serving as a director, supervisors, currently only director and supervisor. But sometimes CEO has more power than the directors. So like the US system, the SEC can ask the federal court to remove unfit person from serving as a director and also officers. So this will be something that we also need to consider in the future. Okay, so finally, one thing I want to mention is that the current regime does not cover if a company has entered into the insolvency or winding up proceeding. So these are one thing that is currently lacking. So we also need to think of the issues, the persons who is engaged in fraudulent trading or other type of misconduct during this process. Thank you very much.
So next, Professor Joon Hyug Chung from Seoul National University will give comments.
The most important one. Yeah, so thank you very much. My name is Joon Hyug Chung from Seoul National University. Please call me Joon. So I already started to love this conference. The good thing to have a conference in Asia is that we don't have any jet lag. There's no time difference. So maybe except for Bruce, who traveled from United States, there's no excuse of being sleepy. So this is a really excellent paper. I really love that. I just summarized very quickly for the sake of efficiency. So if I understand correctly, there are, except for the shareholder meeting dismissal that maybe all countries have, the three features that you have in Taiwan is, the first one is statutory automatic disqualification, like if you commit a crime, like organized crime, fraud, breach, or things like that, then you are banned until sentence period plus some additional years depending on the heaviness of the crime. And the second one is there's a judicial removal of director in case of material damage to the company or serious violation of the laws. And this is, you have that in Article 200 of Company Acts, which is not actively utilized because of the shareholding requirement. But you have the 2009 Investor Protection Act, where a non-financial, I mean like non-profitable organization, SFPC, bringing lawsuit against director. And the last one is the ancillary disqualification legal effect when there's a judicial removal, which is introduced by the 2020 Investors Protection Act. And here, the scope of disqualified person and the cause for disqualification has been expanded from the previous law. And there is 3 years of disqualification upon discharge by the court. And Professor Lin has suggested like a full list of reform, which I really admire his efforts, because he successfully found all the loopholes in the Taiwanese law. So I'm not going to read them all, but I just counted by my fingers, and he found it like almost 11 loopholes that needs amendment in the future law, which I really appreciate, and I will not comment on this because I'm not an expert on this topic. But what I want to say is that more on a fundamental way, why do we need this disqualification regime? You mentioned that you have in Taiwan, we have in UK, you have in the United States, but why do we have that? So maybe the first argument would be that from a ex-ante approach, that if there's a strong disqualification rule, like it can deter violation of laws by directors. So for example, then we need to think that what kind of wrongdoings need special treatment like disqualification. So for example, like of course, if you're a director do something wrong, then he would be or she would be civil or criminally liable. That's for sure. But in addition to that, like we need a special treatment of disqualification. Then why we need it, and what kind of wrongdoings need ex ante like discouragement of doing wrongdoing. So and if it's a good idea, then shall we expand to all crimes and wrongdoings? Like if you, for example, you do a theft, or I don't know, like you cross the road when it's red light, then but nobody would say that let's expand all the wrongdoings in this disqualification regime. So maybe this ex-ante approach sounds quite attractive, but it doesn't explain everything. So the other approach that I was thinking is that maybe the wrongdoers are kind of specialists in doing bad thing using corporate form. And I think that can be a more plausible argument compared to the ex-ante approach. So then we have also a bunch of questions. So the criteria should be that, does a managerial position facilitate the wrongdoings? So that would be one criteria that we can have if we take this approach. Then, like insider trading, maybe yes, because if you become a CEO, you can access to non-material public information. Then I mean like non-public material information. So maybe you are prone to insider trading violation. Harm to creditors, I understand this is the UK approach because they more care about the protection of creditors using the limited liability and corporate entity form. So this is kind of abuse of corporate form. So maybe yes to this question as well. And then tunneling transactions, you have not like explicitly mentioned about tunneling, but most of the embezzlement and breach of trust type of crimes involve sales dealings, tunneling, and things like that. And maybe yes, because if I become a manager, I can influence the company for sales dealings, usurpation of corporate ownership, things like that. So maybe that makes sense. But when it comes to market manipulation, for example, So do I need to be a CEO of the company to become a good market manipulator? Maybe not. And organized crime as well. So if I'm not misunderstanding, it deals with mafia or gang type of crime, right? Then I don't think a relationship of becoming a CEO and doing like facilitating this type of crime. So we need to kind of limit the wrongdoings scope that abuses corporate form and capital market if we take this idea. And continuing on this argument, the specialist approach, what I named it, is that how do we know that they will repeat? We know that maybe they repeated in the past, but we don't know whether they'll repeat in the future. So that's a very, very difficult question to answer. And how the court can know, how can the court know that there will be repeat players abusing the corporate form and capital markets? So maybe are you proposing one strike out since there are many professors who are familiar with the baseball. In baseball, if there's a street strikes, then you're out. And one strikeout means that if you do one wrongdoing, then you're out forever. But maybe it's too strong. And this is a meeting of corporate law professors, but we need to also think about constitutional law issue because maybe this can be efficient means for protecting market investors, but we also need to care about rights for freedom for work and business and things like that. And I think that if similar cases arise in Korea, I'm quite sure that you'll go to the Constitutional Court of Korea to dispute the unconstitutionality. And I think that the mechanism is quite similar in Taiwan as well. So another one last argument that I want to make is that what if a wrongdoer is a great entrepreneur? So maybe in the United States, you have a bunch of people. In China, you have a bunch of elite people. So you can just dump the bad guy and hire the younger one who are a great entrepreneur. But when it comes to a small economy, like you don't have like bunch of pool of great entrepreneur, then which is better for the investors and the market? So I see that you are laughing on my question, but taking it more seriously, so it's a matter of universal disqualification versus selective disqualification with very efficient disgorgement and damage claim regime. So we need to carefully compare which is better, and I can rephrase it as kind of property rule approach because you ban everything, and liability rule approach because you allow something, but you can be liable at the end. So this is also another topic that we need to think quite thoroughly, whether this disqualification regime is kind of one fits all for all crime and things like that. And since this is a comparative study meeting, I want to show the example of Korea. We have quite similar regime. So we have an act called Act on the Aggravated Punishment of Specific Economic Crimes and stuff like that. And you are prohibited of appointed or employed in financial institutions, SOEs, and enterprises having close relations for a certain crime like fraud over a certain amount of money. And Ministry of Justice can approve the exception. So just to explain the background of this regulation is that in Korea, as you know, we have many conglomerates controlling families. And then if there's some wrongdoing, maybe the chairman calls the salary CEO. And then, okay, so if you say that you did all wrongdoings and you go to jail for 3 years and you come back and you'll be promoted. So in order to promote it, to provide this kind of benefit, you cannot hire this kind of people. That started like that. But nowadays, it became more a problem of not the CEO, salary CEOs, but more of the controlling shareholder themselves. So there are many more cases that directly sue controlling shareholders themselves. And we have a very big loophole. And I found a very big loophole maybe that can be helpful to your paper, which is that controlling shareholder can influence the companies without holding any official position. That's how it works. But we cannot say in the law that controlling shareholder, if they commit crime, you need to sell all your shares. That's not something that's not going to happen. So in this qualification regime, there's a big role big loophole, and maybe it has a big limits in controlling control companies. My last point, since we are lacking of time, is I'm really impressed is the role of SFPC. I think that this is very intelligent way of approaching all these litigations, because when you say a good corporate governance, we talk about laws, we talk about how market works, including how many lawsuits do you have in the market. So for example, in Korea, we have good laws, but litigation market is not that active. We have less than 10 lawsuits per year in Korean listed company. And there are many explanations why there is no such litigation, like rational appeal, collective action problem, and things like that. So my question is how SIFPC is evaluated in Taiwan, and whether do you think that the incentive is aligned with the role of FICC and the investors? So thank you very much.
Thank you. Do you want to answer to Professor Chun's remarks?
Yeah, thank you for your comment. This is a big issue. It's a big regime that. So when we were talking about the reform, I'm based on the current practice. Okay, and of course I see from the different jurisdictions, we know why should we need to have a disqualification regime, because those persons, they can come back anytime and doing the same thing again and again in the past. So we see the company doing the wrong thing and they change the name and now they are still there. And so as I just mentioned, juridical person regimes that they can replace representatives, all are controlled by them. But you mentioned several very good questions, particularly regarding first one is the scope. The scope. So what type of crime will make us feel that this person is unqualified to serve as a director? But if we look at the UK code, it also says you commit a indictable crime. Only that. So I haven't looked into the cases to see what type of cases, what kind of crime will disqualify a person. Secondly, we are not disqualifying a person forever. The US, you can disqualify a person forever. But of course, case by case, the court should have the discretion. So basically, we need to impose a length of disqualification. UK 2 to 15 years. US can be forever. And I say the automatic disqualification, the negative qualification regime is also important, because if you look at those crimes that is listed as the negative qualification, it means that if you commit this kind of crime, you cannot serve as a director. Okay, and also so when you are doing this and you are sentenced, the criminal court doesn't need to say you are disqualified, because the law already imposed automatic disqualification legal effect. So this is one thing I'd like to supplement. And the other thing I would like to mention is that current regime, there's no sanction for violation. So once you are disqualified, you can come back. If you are found that you are continue to serve, that's fine. That's fine. We disqualify you again. And you can, okay, I don't want to be a director, but I can be a de facto director. I can be a shadow director. There's no punishment, right? So by UK code, if you do de facto directors, you still will be sent into jail. There's a criminal sanction. I want to supplement until now because Q&A.
Thank you. So I want to open the discussion to the floors. Okay, so first, Alanko.
Thank you, Professor Lin. I think even in Korea or the UK, even Singapore technically has a disqualification regime. But I just wondered, with the global market for managerial talent, you can be disqualified in one regime and probably go somewhere else to work if you're really that well known, right? So I was just wondering, right, also from a private international law perspective, because I also am doing private international law, I was wondering if you might consider introducing some kind of mutual recognition system where you would recognize someone who is disqualified somewhere else as equivalent to being disqualified in your own system, so you don't have these rotating doors for certain notorious board members. So I think just one suggestion, close a further loophole, as it were. The other thing that I was actually thinking about was, I think also in response to Professor Chong's point, that you argue that there should be a good reason, right, to disqualify someone from service for whether it's a company or maybe for the entire capital market. But actually, I think what Professor Lin seems to be saying is about, perhaps maybe better idea to prevent their participation in the economy beyond a certain scale. I mean, fine, you can probably work somewhere. No one's going to stop you from, taking a fast food restaurant job. But there's no reason why anyone should be free to wield the power to influence major market actors or to have exert an impact on the economy that's disproportionate for an individual, especially when there's some kind of economic crime or some kind of reasonable basis for disqualifying the person in the first place. But we can't really have a disqualification from disproportionate economic participation. So we limit it to the position of director or officer, which is at least more legally definable. So I think perhaps we can treat it as a special case where the policy objective is perhaps to prevent them from participating disproportionately in the market. But since we can't achieve that exactly because that would be too unclear, right? And so there's offense rule of law considerations, we'll just limit it to a few examples. This is just a suggestion for a thought. Thanks.
Okay, so please.
Yeah, so I think that the matter you're discussing actually goes beyond corporate law. Because when you disqualify a person, you disqualify him across the system. And therefore, you have to consider issues that are systemic, and especially the integrity of the financial markets. And I think that this is essentially actually an administrative decision. So I had the opportunity to sit on such tribunals when I was a regulator. And the main issue is how you actually construct a system that has the correct checks and balances on that decision-making process. So I think it's important, who makes the decision and who has the authority to check that decision. So you involve here many things in that same thing. So it's a systemic concern that gives rise to the cause of action, but also you involve here constitutional law issues, labor law. So the question is, I think, how you make the systemic design that would just balance all those considerations. So I'm curious to know what do you think about it?
Okay, thank you. I think that is a very good question. In Taiwan, we were talking about, when you are saying disqualifying the person from the spot, you are talking about whether that will influence the market as a whole, and so on and so on. And just like what Alan just mentioned and Professor Chung mentioned about the constitutional issues. This is currently, as I mentioned, submit to the Grand Court to decide. And one of the issues is regarding the constitutional right to work. Okay, but you can work as an employee. You can work as in anywhere. But we just don't want you right now. The regime is limited to the application to the publicly traded corporations. Okay, so we don't want you to be the responsible person in the listed companies, so you don't harm the investing public, and so on. But you can do other non-managerial work or non-directorship work. That you can still have that kind of right to do. Okay, so the current law is thinking about how to balance the right of a person who may be talented in directing the company, but in the past litigation, the wrongdoing, the misconduct are all related to misappropriation of corporate assets. You are engaging in, for example, non-arm's length transaction, but you harm the company's best interest. So you steal the corporate assets away from the company, put into your own pocket or your friend's pocket, and so on. And so market manipulation that was aided into the 2020 amendment. It was not there. So whether market manipulation should be one cause, one kind of crime that we remove the person. But if you look at the U.S. Regime, if you violate the securities regulation, including insider trading, market manipulation, that you can be removed as a director or officer of a public company, something like that.
Thank you. So, any other questions? Okay.
Hi, Professor Lin. I love this topic very much, but I do have a question. So I think the stricter the qualification rules are, the more likely these real controllers will hide into the shadow, right? And I'm not confident that the disqualification of these shadow directors or de facto directors will really work, because they can always change their representatives, right? So do you think this disqualification, director disqualification rule will really play an important role in like family-owned firms or in these parent-owned firms, like in Taiwan or in other East Asia jurisdictions? Thank you.
Yeah.
Can I take? I think we had one more question. Someone? Okay. Okay. So, thank you. Oh.
Okay. Yeah. The question is very a smart question, and it could happen. So my answer is that the law cannot prevent anything to occur in the future. There's no any regime that you can prevent any wrongdoing to occur. But what we can do is, the first thing is that we don't want this person to continue to serve. Of course, you need to go through other person's hand. Okay, so if you can, do it. But the other reason I say is we need to have a sanction for violation. If you look at the UK code, which I appreciate a lot, but I don't know whether Taiwan will just borrow that kind of experience. See that if you violate, not only the disqualified person will be disqualified, will be sanctioned, but also other company you are using the disqualified person, you will also be sanctioned. So if you are someone who hiding behind, you better cross your finger not to be found that you are the one who is hiding behind. Otherwise, you will be sanctioned. But currently, there's no sanctions. So that is why I say, even you have the judicial removal or disqualification regime, that you cannot, effectively perform the function as UK system has. That's what I would like to explain. Yeah.
Thank you. So, any other questions? Do you have one? Okay. Okay. So, thank you very much, Professor Lin and Professor Chung.